Hi guys, I welcome to all of you into our the second series of the chapter High Court. If you have not gone through the first chapter of the High Court, please go and then come back to this second series. So what we are going to learn today is the important power and jurisdiction of the High Court. The first important jurisdiction and the power of High Court is the original jurisdiction. So what does that mean? Take an hypothetical example if X person is the victim and he has some issue regarding some matters. The matters are like marriage, divorce, or maybe company law, or maybe the contempt of the court. Then he, instead of going through subordinate court, instead of following the route of subordinate court and high court, he will directly approach to the high court. Are you getting my point? This is known as the original jurisdiction. It simply means that without appeal, without appeal to the high court, the victim can directly approach to the high court. Okay, instead of following the route of subordinate court and then high court. So which are those matters? Please remember and recall the matters that we learned into the Supreme Court consent. Those are like only related to the federal dispute. If you able to recall, remember that with the federal dispute perspective, there was like a government of India and the state, government of India and state with another state, or the one state with the two or more states. That was regarding the federal dispute. But here, in the perspective of the original jurisdiction of the High Court, the list is little wider one, and which is very important and five-star questions that we can expect from this topic. Okay, so first, as I mentioned, there is a marriage or divorce, or maybe there is a company law, or there is a contempt of court. If anything or any of the issues among these matters happens, then one victim or one individual can directly approach to High Court rather than going through the subordinate court and High Court. Second thing you need to remember, there is also if there is an election dispute in the election process of the member of parliament or maybe member of legislative assembly, that is MPs and MLAs, there we don't have election tribunal. We have to again approach to High Court. This is again so much important. Third matter over here is that revenue collection matter. Then fourth is the fundamental right enforcement. So if any of these four matters are associated with the victim, he can directly approach to High Court instead of going through instead of following the hierarchy of the subordinate court and High Court. I hope you are able to understand. Now, what one thing you need to remember over here is that under the original jurisdiction, the High Court only has the civil matters. The High Court can only handle the civil matters and cannot handle the criminal matters. What is civil matters? In simple way, if there is any issue regarding the law or maybe the facts whatsoever, these are the civil matters. This can be handled by any of the High Court, specifically like Calcutta High Court or Bombay High Court or Madras High Court or Delhi High Court. But if there is any criminal matter, then criminal jurisdiction or criminal matter cannot get handled by the High Court under this original jurisdiction. For that, you have to use the appellate jurisdiction. We'll be moving further. Second is a writ jurisdiction. You have to remember there is a Chandra Kumar case in 1997 which said that the writ jurisdiction of the Supreme Court and High Court is a part of the basic structure. So it cannot be changed by the amendment. So we know that under the Supreme Court there is Article 32 under which the writ jurisdiction of the Supreme Court can be issued. With respect to the High Court, there is Article 226 where the writ jurisdiction of the High Court can be issued. Now over here, you need to remember the very important point which I already explained into our Supreme Court chapter, and if you have not gone through the chapter, please go watch that and come back to this series. So here we need to remember the Supreme Court, the High Court has a wider writ jurisdiction. It means Supreme Court can issue writs only with respect to the fundamental rights. We know which are those writs like habeas corpus, certiorari, mandamus, prohibition. All of these are the writs which are issued concerned with the fundamental right by the Supreme Court. In the respect to the High Court, the writ can be issued along with the fundamental rights with other legal rights as well. So not essentially the High Court can issue writ regarding only to the fundamental right. High Court can issue the writ with the fundamental right if there is a violation of fundamental right or maybe any legal right. I hope you are able to understand. So that's why it is known as the writ jurisdiction of the High Court is much wider than the Supreme Court. Are you getting my point? Because Supreme Court can issue writs only associated with the violation of the fundamental right. High Court can issue the writ under Article 226 when there is a violation of the fundamental right as well as any civil matter. Alright, moving further, the third, appellate jurisdiction of the High Court. So what is appellate jurisdiction? It is again in a simple way to appeal the High Court. Against whom? Against any subordinate court. So one can appeal to the High Court against any of the subordinate court. Now here we can remember that in this appellate jurisdiction, the criminal matters and civil matters both are included. Civil matter, as I already mentioned, that any law or any fact. Okay, but here again very important is that the civil matters can include also some tribunals. So which are those tribunals? For example, Central Administrative Tribunal. Then there is a NGT, National Green Tribunal. Then there is also Tax Commission or Income Tax Tribunal. So if you have any issue or if they have violated your basic right or maybe your legal right, then you can approach to High Court first, not to the Supreme Court. You have to approach by the appeal to directly to the High Court. For example, if there is an IS officer and his legal right or maybe fundamental rights are violated, he have to go to CAT, not to the Supreme Court. Please make note of this. If an ex as an IS officer and if his fundamental rights are get violated or maybe legal rights are getting violated, he have to go to the CAT, like Central Administrative Tribunal first, and then he can go to the Supreme Court. Basically, this issue does not go to the Supreme Court. CAT actually get sorted out. But remember, if you have again issue with this CAT decision or CAT verdict, then you can approach to the High Court under the appellate jurisdiction. Also take example like if there is income tax tribunal and if they have charged you more tax than your salary, then also you can go to the against this income tax tribunal, you can go to the High Court, you can appeal to the High Court. On the same light, like NGT, National Green Tribunal, if you have any issue with respect to the NGT, you can appeal to the High Court against these tribunals. This is basically matters associated with the civil tribunal. Second is the criminal issues or the criminal matters. Which are those criminal matters? In simple way, like a capital punishment, or we say a death sentence. If any subordinate court has given any verdict regarding the death sentence or like a capital punishment, then you can directly appeal to the High Court against the verdict given by the subordinate court. I hope you are understanding it. Just remember, in the original jurisdiction, High Court can handle only the matter associated with the civil issues. In respect to the appellate jurisdiction, High Court can handle the matters those are associated with the criminal matters and as well as the civil matters. I hope you are able to understand this. Moving further, the fourth power of the fourth jurisdiction of the High Court, it is the supervisory jurisdiction. Again, the name itself says that High Court can supervise to the different subordinate courts, but it does not have right to supervise. The most important is the military court. What are these military court? The courts those are actually handles the issue regarding to the Navy, Army or Air Force. So those are the military court where the High Court supervision is not allowed. Only another High Courts under subordinate court, usually the supervision of the High Court can be happen. Now fifth power of this High Court jurisdiction is the control over subordinate court. So of course High Court has power to control the subordinate court, maybe by transferring their judges or maybe appointing the judges, like, or maybe to giving the promotion. But High Court or the Chief Justice of High Court can be done not by himself but by concerning or giving consideration from the governor of that particular state. I hope you are able to understand. Next, moving towards a further important power is a court of record. On the same line what we have learned in the Supreme Court of record, the same to same statements are there with respect to this High Court's court of record. So I will not repeat it again. So I hope you are able to understand what I mean to say.